So.
Oh, so you're not going to be commenting?
No, I'm not. Can you hear me now?
Yeah, and we can hear you fine if you're not going to say anything. You're not going to be.
And, if we're going to submit comments, it may just be in writing. No, I'm not. Can you hear me now?
Okay, are we back to real time? Okay. All right. I had you on the list of folks that were zooming in, and I didn't know where to put you in terms of commenters, but if you're not going to comment, we won't worry about it.
If I do comment, I think I'll use this audio option. Does this sound a little better?
We can hear you all right. It's not great, but
okay.
Do you know, would you be proponing, opponing, or informationing?
Again, today I'm not planning to comment.
Okay.
So
we won't worry about it. Thank you.
Okay. Yeah, thank you.
Hello, can anyone hear me? I have a good connection.
We can hear you, Commissioner.
Thank you.
And Commissioner Fielder is here as well.
And we can hear you, Commissioner Fielder. Thanks. Welcome all. This hearing is called to order. Today is August the 2nd, 2022, and the time is 1 p.m. This is the time and place set for the public hearing on proposed new rule Roman numeral 1 and repeal of ARM 38.2.2401, 38.2.20403, 38.2.2404, 38.2.2405, and 38.2.2406 regarding formal intervention in commission contested cases. I'm Vice President Brant Johnson and will be the presiding officer for today's hearing. Present in the Bollinger Room with us is President Brown and Commissioners Commissioners Fielder, Pinocci, and O'Donnell are participating remotely. Montana law requires the presiding officer at a rulemaking hearing read the following notice. Notice of functions of Administrative Rule Review Committee. Administrative Rule Review is a function of interim committees and the Environmental Quality Council, EQC. The interim committees and the EQC have administrative rule review, program evaluation, and monitoring functions for the following executive branch agencies and the entities attached to agencies for administrative purposes. Economic Affairs Interim Committee oversees Department of Agriculture, Department of Commerce, Department of Labor and Industry, Department of Livestock, Office of the State Auditor and Insurance Commissioner, and Office of Economic Development. Educational and Local Government Interim Committee, the State Board of Education, Board of Public Education, Board of Regents of Higher Education, and Office of Public Instruction. Children, Families, Health, and Human Services Interim Committee, Department of Public Health and Human Services, Law and Justice Interim Committee, Department of Corrections and Department of Justice. Energy and Telecommunications Interim Committee, Department of Public Service Regulation. Revenue and Transportation Interim Committee, Department of Revenue and Department of Transportation. State Administration and Veteran Affairs Interim Committee, Department of Administration, Department of Military Affairs, Office of the Secretary of State. Environmental Quality Council, Department of Environmental Quality, Department of Fish, Wildlife, and Parks, and the Department of Natural Resources and Conservation. Water Policy Interim Committee, who is responsible for quality and quantity of water. Department of Environmental Quality, Department of Fish, Wildlife, and Parks, Department of Natural Resources and Conservation. The interim committees and the EQC have the authority to make recommendations to an agency regarding the adoption, amendment, or repeal of a rule, or to request the agency prepare a statement of the estimated economic impact of a proposal. They also may poll the members of the legislature to determine if a proposed rule is consistent with the intent of the legislature, or during a legislative session, introduce a bill repealing a rule or directing an agency to adopt or amend a rule, or a joint resolution recommending that an agency adopt, amend, or repeal a rule. The interim committees and the EQC welcome comments and invite members of the public to appear before them or to send written statements in order to bring their attention to any difficulties with the existing or proposed rules. The mailing address is P.O. Box 201-706, Helena, Montana, 59620-1706. We now will proceed with the hearing. The notice of public hearing on the proposed rule change was published on July 8th, 2022 in the Montana Administrative Register as MAR Notice Number 38-2-255. A copy of the notice can be found on the Secretary of State's website at sos.mt.gov/ARM/register. The notice of the commission proposes to In the notice, the commission proposes to modernize and simplify its rule concerning formal intervention in commission contested cases. Montana law requires the commission to periodically review its administrative rules. The commission's intervention rules have not been updated since the 1970s. Commission proposes a new intervention rule, which can be found in paragraph 3 of the notice. Simplifies intervention process by allowing uncontested interventions to be deemed approved without further commission action. The new rule also recognizes the special status of the Montana Consumer Council and streamlines MCC's intervention. Finally, the rule recognizes the commission's authority to limit an intervener's participation when necessary to avoid delay, repetition of the issues, or prejudice to other parties. Montana law sets short deadlines for the commission's proceedings, and our ability to satisfy those deadlines may be jeopardized by unnecessary delay or unreasonable duplication of efforts. Paragraph 4 of the notice identifies each of the commission's existing rules that would be replaced by the new rule. Paragraph 5 sets the deadline for written comment regarding the rulemaking, which I will discuss at a later point. Paragraph 6 advises that the MCC may be contacted to represent interests of consumers. Paragraph 7 describes the process for joining the commission's interested persons list for administrative rulemaking. Paragraph 8 states that the department has determined the proposed rule will not significantly and directly impact small businesses. Paragraph 9 notes that a copy of the proposal notice is available on the Secretary of State's website. Paragraph 10 concludes the bill sponsor contact requirements of state law do not apply to this rulemaking. The purpose of this hearing is to receive public comment regarding the proposed rule changes. In addition to this hearing, the written comments regarding the proposed rule changes may be submitted to the commission. All written comments must be submitted to the commission no later than 5 p.m. on August the 8th, 2022. Following the close of public comment period, the commission will summarize and respond to any comments received. And let me be clear that the commission will not offer response to any public comments prior to that deadline of August 8th, 2022. The summarized comments and the commission's response will be published in the Montana Administrative Register as part of the rulemaking process. We now will go to folks to comment with regard to the proposed rule. We will begin by hearing from any proponents. Are there any proponents to speak in behalf of the proposed rule? There are none in the room. Do we have any online? And there are none online. Are there any opponents in the room who wish to speak? Ms. Arnold, and then we'll go to Mr. Repke. Ms. Arnold, you of course understand the drill. Give us your name, who you represent, and please spell your last name for us.
Good afternoon, Mr. Chairman, Commissioners. My name is Robin Arnold, ARNOLD. I represent Renewable Northwest. And I would have to say we are soft opposition to the rules. We don't have any major concerns. However, we will note that one of the rules being repealed conflicts with another rule and with MAPPA. It conflicts with Rule 38.2.3902. Which says that at any hearing, all parties shall be entitled to hear an appearance, introduce evidence, examine and cross-examine witnesses, make arguments, and generally participate in the conduct of the proceeding. We feel that some of this language is being drawn back into Section 8 of the proposed rules, and therefore we recommend an amendment to that language. We would also note that well, the commission has expressed concern about duplication of positions. Generally, it costs a lot of money and takes a lot of time and resources to intervene in commission proceedings. Therefore, oftentimes parties on their own will try to combine as joint interveners whenever possible to reduce the time and cost. So that is not a provision that, at least I'm aware of, has been utilized by the commission in the past, which is probably why the conflict has not really arisen as far as the conflict in rules that appears to exist. But the language we're proposing reflects more practice that the commission has done in the past when the commission has conditioned or limited intervention of parties. And so we propose new language for section 8 to say, at any time in the proceeding, upon notice to the intervener and a reasonable opportunity for the intervener to respond, the commission or hearing examiner may limit or condition an intervener's participation in the proceeding if it finds the intervener is attempting to unduly broaden the issues in the proceeding. We feel that more accurately reflects what the commission has done in the past and also better aligns with both MAPPA and other commission rules. Thank you.
Thank you, Ms. Arnold. Are you going to leave a written copy or submit one or?
I can submit written comments
All
online.
right, thank you. Don't forget August 8th. Thank you. Mr. Repke. Again, if you would identify yourself, who you represent, and spell your name for us.
I'm John Repke, representing myself. Last name is R-E-P-K-E. Mr. Vice President, Mr. President, and Commissioners. I think I agree with some elements of the proposed rule change that modernize the process. However, I do not agree with the provisions that limit any kind of intervention. I think that the Constitution provides a right of participation, and I think that gets close to infringing on that. So therefore, I think it'll be challenged. I think it'll actually make the process less efficient. So I would be in favor of striking that portion of the provision and allowing intervention as it has been. And I think that'll lead to the full gathering of information during the information gathering process and lead ultimately to a more efficient process with better decision making. Thank you.
Thank you, Mr. Repke. And again, if you're going to submit a written version of that testimony, you should do so by the 8th of August. Thank you. We now will move to online commenters. It looks to me like commenter number 1 is Mary Catherine Dunphy from Miles City. Ms. Dunphy, are you with us?
I am with you.
Floor is yours. Again, introduce yourself and spell your name for us, please.
Okay, my name is Mary Catherine Dunphy, Catherine with a C, and Dunphy, D-U-N-P-H-Y, from Miles City, Montana.
Thank you. Go ahead, Ms. Dunphy.
Okay, thank you. Good afternoon, Commissioner President or Commission President James Brown and other commissioners. When I read about the PSC wanting to have the power to limit interveners' participation in cases before the PSC alarm bells went off, I thought, why would the PSC want to limit interveners' participation in cases? The article said it was for efficiency and time saving, which seems like a pretty good reason, except that gathering all the facts in a case always takes time. It's part of your job to discern all the facts from various interveners, which always takes time, generally a lot of time. I know this because I've been a legal secretary and a legal assistant in my life, and I've had to compile a lot of information in cases. I don't know that much about the other industries you all regulate, but I do know a little something about electricity generation. So I will speak to that issue as it relates to this proposed rule change, because it is also a free market issue. For example, why would you all want to limit participation or information by other electricity generating companies in an electricity rate case or a case about electricity production? Do you only want to hear what Northwest Energy or MDU has to say? Sure, that saves time, but it also severely restricts and limits information that other electricity generating companies would be able to provide. Is that your intent, to limit competition or limit facts in a case? Unfortunately, Montana utility companies, our customers, are captive customers of out-of-state investor-owned monopoly utilities. But Montanans deserve to get the cleanest, most reliable, and cheapest electricity available. Do you all not want to hear, for example, what the renewable energy businesses have to say about electricity generation and how reliably and cheaply it can be generated? Incredible things are happening, and technology is evolving so fast in the renewable energy field that it seems you all would not want to limit yourselves to only one side of the story in a case, if only as a matter of education about what is possible and happening and what it portends for the future. Besides the free market angle, this proposed rule change could prevent groups who advocate on behalf of the public interest to intervene in cases and provide you with additional facts. Groups like Montana Environmental Information Center, the Sierra Club, Northern Plains Resource Council, as well as other groups who have an interest in providing additional facts in a case. Maybe you all really don't want to hear what these groups have to say, but they represent thousands of concerned Montana citizens who have to pay electricity bills every month. They deserve to be listened to. It's an important part of your job to listen to and read what they have to say. In fact, it is a right enshrined in the Montana Constitution in Article 2, Section 8, which says, I'll read it for you, the public has the right to expect governmental agencies to afford such reasonable opportunity for citizen participation in the operation of agencies prior to the final decision as may be provided by law. Have you all forgotten that the taxpayers of Montana pay your salaries to protect their economic interests from powerful investor-owned monopoly utilities? Let's not forget the citizens of Montana are paying you big bucks to protect their interests, not the interests of Montana utilities. Gathering all the facts and listening to all the various issues and cases and discerning facts is just doing your job. It's ethical due diligence and due process. To do otherwise is unconscionable. So in closing, I urge you to reconsider this proposed rule change and reject it as being unreasonable and in violation of Article 2, Section 8 of the Montana Constitution. Thank you for your consideration.
Thank you, Ms. Dunphy. And again, would remind you of the August 8th deadline if you wish to submit written comments to the commission. Moving on now to commenter number 2, opponent would be Mr. Ian Lund of Helena. Mr. Lund.
Thank you. Good afternoon, Vice President Johnson, President Brown, Commissioners. My name is Ian Lund, L-U-N-D. I'm speaking on behalf of the Montana Environmental Information Center. MEIC commends the Commission on its efforts to modernize its rules and recognizes the importance of establishing efficient and effective processes. We'd like to note that interveners often bring substantial expertise on important issues considered by the Commission. Over the past 4 years, MEIC has participated in dockets related to proposed utility resource acquisitions, cost recovery under the PCAM, and a general rate case. In these cases, we've submitted testimony from outside expert witnesses, often leaders in their fields, on the appropriate regulatory treatment of utility assets and expenses. Testimony which the Commission would not have heard were MEIC not an intervener. It's worth noting that the Commission's findings have frequently adopted aspects of our expert witnesses' positions. Even when the Commission has not adopted our positions, the Commission's findings have been more credible and durable because of the more robust evidentiary record that MEIC helped create. In short, the participation of interveners ensures that the Commission's decisions are based on the most complete information and analyses available, reducing costs and risks for ratepayers. That said, we are concerned about the language in Section 8 of the draft rule. Section 8 would unreasonably expand the Commission's ability to limit intervener participation in a proceeding. Under the current rules, the Commission may limit intervener participation only when 2 or more interveners have substantially similar interests and positions. And in that case, the Commission may only limit an intervener's ability to cross-examine witnesses, make motions, and raise objections at a hearing. In contrast, the draft rule would allow the Commission to limit or condition an intervener's participation in any manner and during any stage of the proceeding. Here's why we think this might be a problem. First, as written, the rule could plausibly be used to deny interveners the right to protect their substantial interests in the outcome of a proceeding. Normally, they can participate in discovery, submit testimony, or file pretrial motions. As written, this rule would allow the Commission to eliminate these rights without giving the intervener any opportunity to object or be heard. This implicates due process, interferes with the fair conduct of proceedings, and perhaps most importantly, invoking the rule could deprive the Commission of developing a comprehensive evidentiary record necessary to make fully informed decisions in the interests of Montana ratepayers. Such decisions based on an incomplete record due to restricted participation may not only be imperfect, they may be vulnerable on judicial review. Lastly, the draft rules don't align with how the commission historically has operated. Though the current rules already allow the commission to limit intervener participation, the commission rarely invokes the rule. To summarize, we oppose Section 8 of the draft on the basis that it may have the effect of diminishing the quality of the evidentiary record, may interfere with due process rights, and unnecessarily expands an authority that is seldom used. We respectfully ask the commission to either preserve the language in the current rules or amend the draft language such that participation can only be limited under clear prescribed situations rather than any time intervention would simply cause quote unquote delay. For example, we would support the amended language suggested by Ms. Arnold of Renewable Northwest. Thank you.
Thank you, Mr. Lund. And again, if MEIC wishes to submit written comments, please make sure you all do that by the 8th of August. Commenter number 3 would be Mr. David Merrill. Mr. Merrill. Oh, Mr. Merrill is not online with us, so we will move on to Mr. Hal Schmidt of R. Lee. Mr. Schmidt. Mr. Schmidt, are you muted on your end? Perhaps we cannot hear you.
I can see, Mr. Chairman, that Hal Schmidt is muted on the Zoom.
Mr. Schmidt, you are muted on your end of the Zoom application. If you can click the microphone and unmute yourself. Mr. Schmidt, we will come back to you, but for now we're going to move on to Mr. Jim Roach of Missoula. And again, Mr. Schmidt, we will come back and give you an opportunity to comment. Mr. Roach.
Yes, can you hear me okay?
We can, thank you.
All right. Thank you for taking my testimony today. My name is Jim Roach, that's R-O-A-C-H. I live in Missoula. I am not any kind of expert on utility regulation or any kind of legal expert. I'm a retired mill worker. And I want to object to that Section 8 as I understand it. I think that it gives the PSC too much power to limit the testimony of various interveners based on kind of vague and subjective considerations. As just a layperson, I don't have the ability to intervene in any of these cases, and I depend on I depend on the Montana Consumer Council and various nonprofits to be able to advocate for my interest as well as the interests of other ratepayers and the population of the planet basically as a whole. And I think that the utility system is caught in an inertia situation. It has to change because the world is changing so quickly. And I think that we need all the advocacy we can get before the PSC in order to push it to make those changes. And while I recognize right now the PSC doesn't have the purview to deal with like the climate crisis, but it seems to me that eventually, and probably in pretty short order, there's going to be a cost assigned to greenhouse gas emissions. And when that happens, that's going to bring the cost right into the ratepayer. Right now, it's all externalized, but those costs are going to come to the ratepayer eventually, in which case it will be the PSC's purview. At any rate, I don't think it's a good idea to limit the testimony of interveners, or to limit in any way who can intervene, or allow for them to be kicked off to allow their testimony to be disallowed because of vague and kind of subjective considerations. I think efficiency is good, and I appreciate what the PSC is trying to do and increasing their efficiency and updating their rules. But I think that Section 8 rule is just not a good one. It's not specific enough, and it possibly leaves too much room for interveners to be discounted. So I need the interveners, we need the advocacy, and I hope that the PSC will change the language in that Section 8 and facilitate the participation of interveners rather than limit it. And I thank you very much for hearing my testimony. Thanks a bunch.
Mr. Roach, thank you for being with us again. August 8th, deadline for submitting written testimony if you choose to do that. Let's go now to Barbara Tylka, I believe, of Bozeman. Ms. Tylka.
Hi, thank you for the opportunity to speak today. My name is Barbara Tylka, Tylka. Mr. Roach has stolen much of my thunder. I do strongly agree with him that the way Section 8 is worded, it is quite vague and subjective, which would make it easy for interveners to be excluded from the process. Additionally, I have neither the funds nor the expertise many times to address some of the issues that are being addressed by the Public Service Commission. And like Mr. Roach, I do depend on these interveners to protect my interests. As a result, I believe that Section 8 is too broadly written, that yes, it would be nice if things were more efficient and neater, but as we all know, our government is a messy thing, and the more participation that there is, while it might not be neat, guarantees that you are most likely to hear all the views that are present. Thank you.
Thank you, Ms. Tylka. Again, August 8th deadline if you wish to submit written comments. Move on now to an informational witness, Ms. Joanne, is it, I believe, Gores?
Yes, Joanne Gores.
Well, you have the floor, Ms. Gores.
Okay, thank you. My name is Joanne Gores. That last name is spelled Gores. And yes, I do have questions for you. I also would agree with the people that have presented in this opponent state. I appreciate their further information. I did some research. My background is a retired English teacher in Montana. I've taught many high school English students throughout my career. What is concerning me is a quote that I saw in 3 newspapers on July 7th, 2022, the Missoulian, I believe it was in the IR, and it was also in the Billings paper, and I live in Helena. And that is a quote from Commissioner Fielder, who said, quote, "So much abuse of parties is coming in and clogging up the wheels of justice with a number of people that really don't have a standing, making a long stretch that they do have a standing," unquote. And my question to you, commissioners, is who are these people she's referring to that don't have a standing? I don't understand that at all. I taught my students that everybody has a voice when it comes to democracy. And I don't understand why all of a sudden there's certain people that don't have a standing when all of us are ratepayers and all of us pay your salaries. Hello.
Thank you, Ms. Gores. We appreciate that. And again, August 8th, deadline for written comments.
Can you answer those questions for me?
No, ma'am. There, as I said at the beginning of the proceedings, we will respond to comments after the August 8th deadline.
Okay.
Mr. Chairman, since my name was invoked there, I'd just like to clarify for the record that I made no comments to the press in response to or in relation to this proceeding whatsoever. If they quoted me on something, it was a side discussion. It had nothing to do with my role as a public service commissioner, and I made that clear the only time I spoke to the press in the last several months, that I was not speaking as a public service commissioner. And I don't know how, I didn't know these quotes appeared, but I was unaware that they had been put into context with this proceeding. That was inappropriate of the press to do that. I think I should proceed with asking for a retraction of that.
Thank you for the clarification, Ms. Fielder. I appreciate that. I will say that it was in more than one newspaper. And when I was looking through this is why I registered as an informational person. I just was concerned because I also saw that there were lawsuits filed against the media. I just want some transparency here. I know the PSC does a lot, but you're also paid to do a lot. And I don't have a lot of trust in the PSC, to tell you the truth. I'll tell you that in my background, because I have worked as a case manager and I have seen people's rates for their utilities triple in 2 months, causing them to lose housing. So I just, I'm real concerned all the way through about transparency. And I'm listening to these other people who are opponents. I totally understand what they're saying, and I agree with what they're saying. I don't think that, I would like to know which groups you think should be limited in their intervening. I think we all deserve our voice. We are all Montanans and we are all citizens. Thank you.
Thank you, Ms. Gores. With that, Mr. Schmidt has advised us that he has submitted written comments and will not be joining us live at this proceeding. So that concludes the commenters both in the room and online for the purpose of the hearing. I should point out that the Commission does maintain a list of interested persons and the subjects in which these persons are interested. Within 3 days of any rulemaking notice being published, all interested persons are notified about the rulemaking activity. If anyone in the room would like to be placed on that interested persons list, there is a sign-up sheet available. And I believe you can also sign up at the website to be included on that list and indicate the issues in which you might be interested. And with that, we will close this public hearing. One other matter pursuant to Montana Code annotated 2-3-103, every commission meeting must include an opportunity for the public to comment on any public matter that is not on the agenda but is within the commission's jurisdiction. So at this time, I would ask anyone who wishes to make public comment on matters not on today's agenda to be recognized and do so. Is there anyone who wishes to make public comment at this time in the room? Seeing none, is there anyone online, Mr. English? All right, seeing no one who wishes to make public comment, we then will conclude.
I would like to make public comment.
Oh, Ms. Dunphy, very well. This is something other than in regard to the rulemaking.
Yes.
All right, go ahead. The floor is yours.
Thank you very much for bringing this up. I appreciate the opportunity to speak. You know, I was raised, I'm 70 years old, and I was raised in the 50s and early 60s, and, you know, girls weren't supposed, I wasn't raised to like talk to public service commissioners, so I really appreciate this. But, you know, I also wasn't raised to like study electricity generation, that kind of thing. But, you know, the world has changed quite a bit, and I have been doing a lot of research online on YouTube about electricity generation. And I would urge all the commissioners to get on YouTube and watch some of the videos about the renewable energy things that are happening. Elon Musk has some great videos about what Pacific Gas and Electric is doing out in California with the Tesla battery backup to make reliable, cheap, clean electricity. And there are other utilities all across the countries that are doing this kind of thing. It's absolutely incredible and amazing. And it gives me so much hope about what's possible for the future. And the future is wind, solar, and battery backup. And Tony Seba is another one that has excellent videos on YouTube about what the future portends. And one of his videos starts off, with a picture of Fifth Avenue in New York City in 1903. And the picture is, all the horses on Fifth Avenue. And he says, can you see the car? And there's one car amidst all these horses and wagons and that kind. 13 years later, from the same angle is a photograph of all the cars on Fifth Avenue. And Mr. Seba asked people to see if they could find the horse. That is how fast electricity generation is changing in this country right now. He goes on to explain why. And, for another example is, you all probably have a smartphone in your pocket right now. You didn't have a smartphone in your pocket in 2006. And here we are 15 years later, roughly 16. And we've all got smartphones. That is how fast this technology is changing. And I would urge every commissioner present who can hear me speak today to get on YouTube and educate yourselves about what is happening and what the future portends and how great it's going to be. So Tony Seba, SEBA, and Elon Musk, and his power walls and his battery backups, and other countries, Australia, you see what they're doing. It's absolutely amazing. So that's my comment, and I appreciate the opportunity to share this. Thank you.
And we thank you, Ms. Dunphy. I believe, unless there's further public comment, and we will close this proceeding. The time is 1:37 p.m. and we are adjourned. Thank you all very much.